Hello, in this video you'll learn about the hot issues for personal injury in 2021, including the way that COVID-19 impacts the court system and potential claims, the costs that a claimant has to pay to their solicitors, issues of fundamental dishonesty in personal injury claims, fatal accident claims and accommodation claims. I'm joined to discuss them by Harry Trusted. Harry Trusted is a barrister at Outer Temple Chambers. He's a specialist in personal injury and clinical negligence cases. He's a founder editor of Facts and Figures, and in the last year he helped to negotiate settlements worth in total in excess of £150 million. Harry, I know the first thing you wanted to talk about is COVID-19 and the impact it has on personal injury claims. I think it splits into two parts. First of all, the impacts on the court and the court system. Second of all, new types of claims that might come about as a result of COVID-19.
The courts have been put under tremendous pressure by COVID-19, as have so many other services provided. In the civil courts, which is what we are concerned with in injury claims, that is to say courts where you have cases decided just by a judge and not by a jury, it is possible to have trials remotely with everybody giving evidence down a camera. But there are real issues with that. Everything takes longer, and in some circumstances, it's just not a fair way to dispose of a case. And the practical effect of that is that even if a case is suitable for a remote trial, it will take longer to come to court. There is another aspect of civil injury litigation which you may need to be aware of, which is this. In the ordinary way, experts, medical experts, see injured people and prepare reports. Some such reports can be prepared on a Zoom basis. For example, a psychiatrist may be prepared to interview somebody to make an analysis of depression following injury or whatever. But in other cases, such as pain management or orthopedics, it's very difficult to have a satisfactory medical report on the basis of something down a Zoom line. The third point I would say is that in a substantial case, barristers and solicitors representing a claimant will want to see them at home, see how they are managing in relation to independence, whether they're in the right sort of building, whether they can manage to get in and out of their car safely, all of those sorts of things, whether they need a wheelchair. That is something which cannot really be accomplished via Zoom. Of course, you can see people at home, but it's not the same thing as actually going to someone and working out what their needs really are. And of course, I have to say, insofar as the litigation team are providing support for those they represent, it's a much less successful and satisfactory means of really getting to know your client and making them understand the limitations and the possibilities of the legal process.
A relative of mine was in a car crash about 2 years ago, and by the time he was ready to get a proper medical report from an orthopaedic surgeon, COVID had struck and he's been unable to see anybody for the last year. How long do you think the situation is going to continue for? Because certainly for my friend, it's stopping the settlement of his personal injury claim.
Well, I don't think the Prime Minister or the President of the United States or Anthony Fauci or any of these other very distinguished people can answer that question, so I don't think I can either. All I can say really is this. I do not think we will achieve fluent and easy access to doctors for reports unless and until this COVID outbreak is really brought under control. And for what it's worth, my guess is that might mean we are perhaps as much as a year away as getting to that point. Sadly, I wish we weren't, but it's no more than a guess, I'm afraid.
So that's the practical side of getting cases through the courts. What about new sorts of claims that might come around because of COVID? Are existing causes of action going to be treated differently because of COVID, or are there brand new types of cause of action that now arise?
Yes. I think there are two aspects to this. One is, of course, that existing claims may be affected by it. So that, for example, if someone is bringing a claim for loss of earnings on the basis that the injury prevented from work, the defendant may take the point that they would have lost their job or been furloughed anyway as a result of COVID, which has nothing to do with the Index accident. So that's one aspect of, as it were, the claim.
That's actually a really interesting point. How do you think a judge would approach the decision about the chances of somebody being placed on furlough or potentially made redundant?
By listening to evidence of fact. So the judge would want to know from perhaps somebody's manager or from an accountant in the firm they'd worked for. If somebody was running their own business, there might be evidence from customers.
Given most personal injury claims are backed by an insurance company, is there a risk that the employer might not want to become involved?
Well, I like to think that people would give evidence as it is. I do actually think that most people are honest. And if they are asked to provide a witness statement, will do their best to tell the truth, even if at one level it isn't in their interests.
That deals with the impact of COVID on normal types of claims. Are there new types of claims now able to be brought that we wouldn't have seen this time last year?
Well, clearly somebody who is required to work in an environment which has not been adequately protected, where they've not been given sufficient PPE or where they come into contact with people who are infectious in circumstances which mean they become infected themselves. That would be an obvious source of potential claim. I would emphasize, though, that I think that the courts would be reluctant to, as they would put it, open the floodgates on such litigation. An employer who was able to show they'd done something would probably get away with it. Yeah? There's one other thing that I think is probably more in theory than in practice, which is clinical negligence. Somebody might try and argue that because they had treatment delayed or mismanaged, perhaps in the wake of the disruption to the NHS caused by COVID, that would disclose a claim. Now, I think that you can see that in one of two ways. On the one hand, you can see that the claim is more likely. On the other hand, you can see that it might actually provide some sort of a defense for a hard-pressed health authority to say, well, we're doing our best, and there we are. Again, I think that the courts would side with the health authority. Unless it was a very clear case, the chances are that claims on that footing would fail as a matter of public interest.
I've always thought it would be very difficult for somebody to succeed in a claim that they've caught coronavirus because of an unsafe working practice or an unsafe place of work, because the employer or the employer's insurers are just going to turn around and say, well, prove causation, prove that you didn't catch it on the bus, prove that you didn't catch it on the tube, prove you didn't catch it from your friends, from your children who are all at school. How does a claimant get around that very practical difficulty of needing to establish causation?
I think you should never underestimate the importance of witnesses of fact. If a claimant is able to show by bringing to court people who have been with him or her at home and are able to establish, as it were, that nobody else at home had the disease until the claimant brought it back from work, that would be a very good start. Having said that, of course, if the claimant has to go to work on the tube or whatever it is, then the causation arguments you outline are more powerful. But it's perhaps worth saying this. COVID outbreaks, as I understand it, occur in clusters. If at a certain workplace a lot of people became infected within a relatively short time, and the court was aware of that, again, witnesses of fact, I think that would tend to nudge the burden of proof in favour of the claimant. Equally, of course, the absence of such evidence might have the opposite effect.
When I used to practice in personal injury when I started at the bar in the early 1990s, anyone could turn their hand to personal injury and cost was a pretty straightforward issue. But I no longer recognise the landscape when it comes to costs in personal injury claims. What would you say, Harry, are the hot issues for costs, particularly costs between a claimant and their solicitor in 2021?
Well, it depends a bit on the value of your claim. The work that I do is predominantly claims, in fact exclusively really, claims in the so-called multi-track, which means that they're over £25,000. Below that there are fixed cost rules which are not really what I do. But in the higher value claims you have what is called costs management. That means that the court will set a budget for things which should be adhered to, and will be the basis upon which the unsuccessful party pays the successful party.
Are there any qualifications to that?
First, very often considerable costs arise on both sides of the case before the case management happens at all. And those costs are then assessed in the usual way at the end of the case. They are not set by the court at all. Secondly, a claimant usually has the benefit of what is called qualified one-way costs, and that is known as QWOCs for short. Costs shifting means that if the claimant loses against an insurance company in the ordinary way, the insurance company will have to bear their own costs. So that means that the risk to the claimant is that much lower. However, there are still certain risks which do exist. In particular, if a claimant continues to litigate after a reasonable offer has been made under Part 36 of the rules, then there will be a cost penalty. And there are other circumstances which are a bit more obscure, where again there may be cost penalties. And that means that claimants are required, when they instruct solicitors, to take out some cost insurance for which they will pay and which they will not recover from the other side. In most cases, that is no more than £1,000 or £2,000, which is usually a small fraction of the award. The figure may rise if the case goes all the way to trial.
Who normally pays the insurance? Does the claimant have to take out a loan for it?
Generally, the solicitors fund it up front, but will deduct it from the damages at the end of the case. Of course, all solicitors work on no win, no fee. So if the claimant fails completely, then there's no bill at all to the claimant. It's only if they win they have to pay.
Can the solicitors ever take a share of the compensation that the claimant gets?
I should say solicitors offer different terms. It is not always the case that the solicitors who offer the most attractive terms to the claimant will necessarily give the best service. A claimant may do better to go to an expensive but well-organised solicitor, even if they lose a chunk of their money, because they will get more money net, even of the deduction, than if they go to someone who isn't really top-notch.
Is that a decision they can realistically make at the beginning of the claim, or is the quality and the cost of the solicitor something that really you need the benefit of hindsight to judge what level of solicitor you should be going with?
Well, they will know what the cost contribution is from the start, because the solicitor is required by the Law Society to give them a written terms and conditions, including any deductions, when they start, or even before they start, so they know if they want to shop around. I would strongly advise anybody with a serious injury claim to look exclusively at firms of solicitors which have extensive experience of handling this kind of work.
Can you give an example of some firms that you know or you've worked with or you'd recommend that specialise in personal injury law?
There are firms, for example, Irwin Mitchell, which is a national firm which provides an excellent service. There's Anthony Gold in central London. There's Enable Law and Clark Wilmot in the West Country. There's Moore Barlow, who have offices in the south of England. All of those firms have first-class solicitors, and they will give you the best service. And I emphasise that anybody badly injured needs to be represented by a specialist team. The days when you went along to your high street solicitor who conveyed your house, did your will, and represented you if you had an injury claim are very long gone, I'm afraid. It may be romantic, but it's really not a good way to get yourself sorted out if you have the misfortune to suffer an injury.
We'll include links to those 5 firms in the notes below. Is there anything else you'd like to say about costs in personal injury litigation?
I want to give examples of the kind of deductions solicitors make. First, they may expect their client to pay any unrecovered costs which are not achieved from the other side even after settlement or judgment. Secondly, they may require an uplift of their costs which will be limited to 25% of certain losses. These are not, in the scheme of things, enormous deductions, but the solicitors are entitled to make them.
The next topic we're going to be dealing with is fundamentally dishonest claims. Just before we do, if you find this video useful, please do like it. I'll give you 5 seconds to do it. 5, 4, it's very easy. 3, 2, 1. Hope you did. Thank you so much. Harry Trusted. What happens if someone who's suffered a genuine injury exaggerates it for the court proceedings?
They are in danger of having their entire claim struck out. This is now part of the procedural rules, the effect of which is that if somebody has a genuine injury for which they have an entitlement to damages, but they tell lies, the whole claim will fail, unless the court regards that as being a substantial injustice, and it usually won't. So if somebody intentionally deceives their own solicitors and the other side and the judge by saying that they were earning more than they were, or that some need is greater than it really is, or whatever it may be, that will be sufficient to trigger the rule, which means that the whole claim fails. Additionally, whereas in the ordinary way an unsuccessful injury claim will not be followed by an order for costs in favour of the insurers, if people tell lies or exaggerate, they are in danger of being pursued for costs by the insurers, as well as losing their case. They may also be pursued for costs by their own solicitors, who of course have no recourse to the insurers on the other side. So in a word, don't. It's a disaster, and any competent solicitor or barrister will investigate their own claim carefully and make sure that every aspect of the schedule is verifiable.
How bad does the dishonesty have to be? I can understand that if I claim to have broken or dislocated my shoulder when in fact I hadn't done so, a court's going to think that's fundamentally dishonest. But what if I said I was mitigating my loss and looking for 5 jobs a week, when in reality the evidence only showed I was looking for, say, 3 jobs a week? How would a court approach that in terms of whether it's fundamental dishonesty?
I think in that sort of case, providing the court accepted that they were just doing their best and it was a bit of a guesstimate, which it probably would be in that sort of example, they'd be okay. But there was a case that went to the Court of Appeal of a man who was working on the Olympic site and suffered a broken arm. And the broken arm was genuine, the injury was caused by negligence, and that was accepted. But this man told lies about the amount of gardening help he had had to pay for following his broken arm, and that was enough to destroy the whole claim.
I know there are some special rules about when the claimant dies in fatal accident claims. Have there been any recent cases handed down in the last couple of years that affect the way that courts approach fatal claims?
Yes. In the last 18 months or so, there have been 2 cases, Blake and Mad Max and AB and KL, which both concerned the deaths of men who were supporting young families. And the judgments give some useful clarification on points of interest to injury lawyers. In AB and KL, the judge accepted that both the twins and the older man were entitled to damages for benefits which their father would have provided had he not been killed in the accident. So, for example, awards were made for a contribution towards the cost of their first home, towards things like birthday presents, driving lessons, and various incidentals which the late father would have bought. The unusual feature of that case was that at the time of the trial, indeed at the time of the death, the father was divorced from the boy's mother. The 26-year-old was living completely independently, and the twins were with their mother but saw their father at weekends. And the effect of the judgment is to expand at least slightly the concept of dependency to allow for circumstances where there isn't just a nuclear family with the ordinary rules of percentage deductions for dependency applying in a straightforward way.
You also mentioned Blake and Mad Max.
Blake and Mad Max was a case which updated certain other specific things, in particular the so-called loss of consortium claims. Now, people sometimes feel with, I have to say, justification, that the awards made for the emotional pain of losing someone close to you are really pretty derisory. The standard statutory award is now just under £15,000 if you lose a child under the age of 18 or if you lose your spouse in an accident. And that is really pretty much it. But in Blake and Mad Max, the judge did make an award of an additional £3,000 for so-called loss of consortium to the wife, and also a modest award to the children, as was also made in A, B and KL. These are low sums of money in the scheme of things. If somebody dies, the real value of the claim will be in relation to the dependency, that is to say, the earnings which are no longer provided, or the childcare which is no longer provided if the person who's died was principally responsible for looking after particularly young children. But these little bits and pieces do add a bit to the claims. They may be some kind of consolation to those who are bringing the claims, and these are useful authorities to read if you have a fatal claim and you want to know what will succeed or what won't. And that, of course, applies whether you're representing a claimant or a defendant.
This brings us to accommodation claims, the last topic. And by the way, if you find this video helpful, I do have a load of other videos on this channel. Please do subscribe to the channel and click the notification bell. Now, I know there was a big case last year called Swift and Carpenter. Just before I ask you about that, can you explain in simple language, because I don't know a lot about it, what an accommodation claim actually is?
If somebody sustains injuries as a result of the negligence of a defendant, and those injuries mean that they reasonably require to be rehoused, then an accommodation claim can be brought. So, for example, if somebody is confined to a wheelchair, they are not going to be able to continue to live in a house which has lots of stairs in it, or any stairs in it. If someone has suffered an amputated leg, the same applies. If someone has a brain injury and needs to have a live-in carer, then there will need to be provision made for that if they are to be able to continue to live in their own home. So it's basically severe injuries which mean that somebody reasonably needs to be living in a suitable home.
Thank you. That's very clear. So what's Swift and Carpenter? What did it hold? What's it all about?
Very simply, if somebody needs to buy a more expensive house, and perhaps they need, say, £500,000 of extra money for this extra expensive home, there is a problem. Because if you give someone the £500,000 and 5 years later they die, there's a windfall to the estate. And the result is that the insurance company or the health authority that's paid the money loses out. On the other hand, if you don't give them the £500,000, then you have someone sitting in a wheelchair who's in a house full of stairs, which is completely useless to them. So what Swift and Carpenter decided, and I'm not going to give the technical details, but in essence, it provided a mechanism whereby you get a percentage of the additional cost, and the longer you are likely to live, the nearer to 100% you get. So if you're a child and you're going to live in the house for 50 years, you get pretty much the whole lot. If you're somebody who's only going to be there for 2 or 3 years, perhaps because you're very elderly and you've got limited life expectancy, you will get some money, but not a great deal of it. And the court set out a clear, and I have to say, a very sensible mechanism by which that is calculated.
Compared with the old way of how these things were done, is this a shift in favour of the claimant or a shift in favour of the defendant?
It depends a bit what you mean by the old way, Daniel. In 1989, when interest rates were much higher than they are now, the effect was probably much as it is today. But when interest rates fell very dramatically in 2009 and have fallen even more dramatically since because of COVID, we ended up in a system where the old way of compensating people didn't really work at all, because the effect was to give the claimant nothing. And there was endless debate about the right outcome. Claims were settled, but nobody really knew what the law was, and it was a mess. And I'm very glad that we now have a clear judgment from the Court of Appeal and we know what we're up to.
Harry, thank you. Harry Trusted is a specialist personal injury and clinical negligence barrister at Outer Temple Chambers. If you want to see some other videos on hot topics of 2021, click here, have a look there. If you want to see my favourite video, have a look at that one. And if you want to ask me a question about any aspect of the law, if you have a question that you want to ask me, have a look at that video there. Thank you so much for watching. I'm Barrister Daniel Barnett. Bye bye.